Welcome and thank you to everyone on the line who has joined World Law Group's e-conference. I am Hannah Shea and I am the manager for communications and network development with World Law Group. Everyone, with the exception of our panelists, will be muted for the duration of the presentation. We ask that if you have questions, you put them in the Q&A feature on the bottom of the screen. If you have the same question as another attendee that hasn't been answered yet, please upvote that outstanding question. We will try to address questions as they present themselves, and if not, we will get them at the end. If we don't get to all of the questions, we will address them in a recap of the presentation. If you experience technical difficulties, you can note your problem in the chat area and we will try to assist you. At the end of the presentation, there will be an option to complete a quick survey. Please take 1 minute to complete this. This session is being recorded and will be posted on the conference website so that you can refer back to it and share it with your colleagues. For those of you who are new or unfamiliar with World Law Group, we are a leading network of independent law firms across the globe with 59 member firms and more than 18,000 lawyers in our network across 89 countries and in more than 400 offices. We collaborate globally through 15 practice and industry groups, as well as our forums, programs, and committees, and in 2019, shared more than 2,600 referrals among our member firms. Our members are deeply established and respected firms in their markets with in-depth knowledge of the local business community, customs, and culture. For more information on the network, please visit our website. With that, I will now hand this over to our moderator, Philip Dickinman, to begin the panel.
Thank you, Hannah. Welcome to our World Law Group e-conference. My name is Philip Dickinman, and I have the honor to be the moderator of today's session. Of course, we would have loved to meet all in person at the fall conference in Atlanta. As this is not possible, our World Law Group team has thankfully organized our fall e-conference so that we still can exchange information, views, and ideas. Today, we hold a session jointly organized by the Dispute Resolution, the IP-IT, and the Human Resources Practice Groups of the World Law Group. The title of our session is Protecting Trade Secrets when Facing Lawsuits or Alternative Dispute Resolution Procedures. We would like to address the options for companies to protect their trade secrets when dispute resolution procedures are about to start or already pending. I will ask 5 questions to our panelists who will cover the legal situation in Asia, in Europe, as well as in America. The audience is not only welcome, but requested to raise additional questions or place comments by using the Q&A tool. And to the extent possible, as already mentioned by Hannah, we will address your questions live during our today's sessions. Before we start, I would like to introduce you to our panelists. We have Jane Wang. She's a partner at Formosa Transnational, our World Law Group member in Taiwan. Our focus is on intellectual property, data protection, and technology, media, and telecom. Jane is also a litigator. She is the co-head of our World Law Group IP and IT practice group. Then we have Julia Wolf. She's a partner in Notary Public of Taylor Wessing, one of our 2 World Law Group member firms in Germany. At the Frankfurt office of Taylor Wessing, she built up the specialist practice areas for intellectual property law and copyright law. Julia is also a co-head of our IP and IT practice group. Our third panelist is Ryan Kurtz, a partner at Miller Martin, one of our US member firms. He is based in Atlanta, Georgia. And he's obviously now much more relaxed since he's not a host. Ryan helps companies protect their businesses and overcome legal challenges before, during, and after dispute arise. Among others, he has a significant experience resolving business and commercial disputes involving intellectual property and trade secret issues. He is a co-chair of the World Law Group Dispute Resolution Practice Group. And our fourth panelist is Indran Sean Muganathan, a partner of Sean Delamore, our Malaysian World Law Group member firm. He's based in Kuala Lumpur. Indran's practice largely relates to trademark, copyright, patent, and industrial design litigation. Indran regularly appears as lead counsel in complex and novel cases, some of which have been landmark IP cases. And last but not least, I would like to introduce you to Jonathan Chamberlain, a partner at Goling WLG, our English member firm. He's located in London. Jonathan practices employment law, where he has a particular focus on business protection. Recent cases have involved safeguarding clients' confidential information in Formula One racing and high-value consumer goods, as well as dealing with team moves in financial services. And my name is Philipp Dickenmann. I'm a partner at CMS Switzerland, and I'm based in Zurich. My core practice are dispute resolution and commercial work. I'm also a co-head of the World Law Dispute Resolution Group. And in addition, I head the CMS Dispute Resolution Department in Zurich. Now, let us start with our topic, the protection of trade secrets when it comes to dispute resolution. My first question is, when a company becomes a party to dispute resolution proceeding, is there an automatic protection for trade secrets, or is it necessary to apply for protection? And how is such application made? And what protection is available? And for what kind of trade secrets? I would like Indran to start with the situation in Malaysia.
Thank you, Philip. And may I just wish everyone good morning, good afternoon, good evening, good night, depending on where your time zone is. As a general rule, and I think maybe I shall distinguish between how trade secrets are dealt with in the civil courts as well as alternative dispute resolution, since that's the subject matter of the topic. Now, in the civil courts, there's no automatic protection for trade secrets. And as a general rule, all documents that are relevant and witnesses which would be able to provide evidence in a particular case would have to come and give, the evidence has to be produced, and the witnesses are compellable to give evidence as well. The only issue is whether they're relevant or not. So what happens to a trade secret then? Would it be automatically protected? The answer is no. And how do you go about then protecting that trade secret in a civil litigation setup in the civil courts? You would have to apply for a protection order or a sealing order. And before that can be done, you would have to persuade the judge that the information or the documents or the witness testimony has the necessary elements of being a trade secret or confidential information. There's general principles here that will apply. Essentially, the information must be confidential in nature, in that it's not in the public domain. Secondly, the information was imparted in an occasion of confidence, which usually would arise in an employer-employee kind of setup, for an example. And if the information is disclosed, it will result in damage to the person whose trade secret it is. So you need to persuade the judge that you're applying for the protective order, that the trade secret or the information that you're seeking to protect has these necessary ingredients. And then what the court would do is they would conduct a balancing exercise to determine whether the information should be kept secret, or would it be in the interest of justice to prevent its disclosure? Because at the end of the day, the court has to make a determination on the merits of a particular case. And if the trade secret or information is necessary for that, then the court will have to then balance those conflicting interests and then decide whether to admit the trade secret or not. A middle ground would be the protective order, where the court will then say that the information could be released under limited circumstances, in the sense that it will be released to just the parties or their respective counsels or certain expert witnesses, and not necessarily to the general public The proceedings may be held in camera, and if there are documents, and generally documents that are tendered in court are publicly available. So what the court could do is also impose a sealing order on the document to ensure that the public would not have access to those documents. So in the court setup, in the civil court setup, there's no automatic protection. You'd have to go to a judge and persuade the judge, with proving that the information has all the necessary ingredients, and then the court performs a balancing exercise and then either imposes a protective order or sealing order. Now that happens in the civil courts. Now what happens in alternative dispute resolution? Now alternative dispute resolution is largely dependent on how the parties can agree to the manner in which the dispute is resolved, and sometimes the parties can make arrangements before they refer the matter to alternative dispute resolution as to how they keep the documents confidential. Now, in Malaysia, we also have an arbitration act. So if the proceedings goes via a dispute resolution which is governed by the arbitration act, there's a general provision of confidentiality where both parties need to maintain confidentiality of all documents that are tendered and all evidence that are tendered during the course of an alternative dispute resolution. It's important to stress here that that may not apply to third parties who are not parties to the proceedings. So again, there's no automatic confidentiality even for alternative dispute resolution, and it will be subject to the parties trying to ensure that the information is kept confidential.
Thank you much, Indran. Now we move to Germany. Julia.
Okay, thank you, Philip. It's a pleasure to talk to you all and see that we have so many of our members in the audience, and I hope it's interesting for them. Let me tell about the situation, especially in Germany, but also in Europe. There is, like in Malaysia, no automatic protection of trade secrets. Usually everything has to be published to the parties which might be of importance to decide the case. But different than the situation in Malaysia, it depends on what can be done, whether the proceedings are state court proceedings or they are arbitration proceedings, and in case there are state court proceedings, it has to be distinguished whether the claim is based on the German Trade Secret Act or it is based on other laws. State court proceedings based on the German Trade Secret Act. Here, the situation should be very similar in all European countries, as the German Trade Secrets Act is based on a European directive. Only at the request of one of the parties, the court may classify information in dispute in whole or in part confidential. If such a classification is made, the parties, their counsel, witnesses, experts, and other representatives, and all other persons involved in the trade secrets proceedings or having access to the documents must keep them confidential and may not use or disclose such information outside of the proceedings. If classified by the court as confidential, third parties who have the right to access to the court files will only get documents in which the trade secrets have been made unrecognizable. Further, the court may, at the request of a party, restrict access in the whole or in part to a certain number of reliable persons, to the documents submitted or produced, to the oral hearings, and to the recording of the minutes, to the recording or the minutes of the hearing. This applies only to the extent that after weighing all arguments, the interest to protect the trade secrets are overweighing all other interests, especially those of the parties to get to know everything. This also is true for preliminary injunction. In case a claim is not based on the Trade Secrets Act, that means is the question in dispute is not a claim regarding the unlawful obtaining or disclosure of a trade secret, but for example, it's a claim of an employee against his employer as of not paying his salary. The following measures are available. There are only very few measures. The court may exclude the public from the oral hearing or from parts thereof if an important secret is raised and the public disclosure would harm overriding interests worthy of protection. The measures can be taken other than in a trade secrets proceedings on request of a party or ex officio at the court's discretion. In the arbitration proceedings, I think there's no difference between the European situation. It depends on the rules of the respective arbitration board. I think it's the most easiest, the WIPO arbitration. So everything shall be in private anyhow, and every other is decided between the parties and the arbitration court. So I think that's the main aspects under German and also under European law.
Thank you much, Julia. Good morning, Ryan. Can you tell us about the situation in the US?
Yes, thank you, Philip. And good morning, good evening, good afternoon to everyone out there. In the US, the court system, there is no automatic protection for trade secrets like the other jurisdictions that we've heard from have to apply for this protection. And it's important to understand in the US, the starting point is that US court proceedings are open to the public, that the public and the press have a qualified constitutional First Amendment right to access to information that's filed and presented to the courts. At the same time, most of the courts and judges recognize the need to protect the confidentiality of trade secrets and other proprietary information. And so there is this balancing act that occurs when one is litigating with respect to trade secrets. Fortunately, there's a rule of civil procedure that's present in both our federal system and all of our state courts that allows for the entry of what we call protective orders. And this is a very common way and the best way to protect trade secrets in US courts. Under this rule, the courts can enter an order to protect trade secrets information in various ways. This typically happens in two important ways, and it's routine. These protective orders are routinely used in trade secret cases. They typically allow, number one, for the filing of materials with the court, what we call under seal, which basically means in private, they're not available to the public. And these under seal filings allow the parties to present information to the judge and to the court, which contain trade secret information that they don't want the public to see. The other important aspect of these protective orders that's typically addressed and allowed governs really the exchange of information among the parties during the litigation process. As many of you know, in the US, our discovery rules, our pretrial discovery rules are quite broad and allow for the exchange of a vast amount of information. And these protective orders typically allow the parties to designate certain information as either being confidential or a trade secret, and the protective order will typically also address who can see that information that's being exchanged. And often in trade secret cases, we use what's called an attorney's eyes only designation. And so the trade secrets and documents that are produced to the other party during the litigation that contain trade secrets can only be shared with your opposing party's counsel. Now that often presents another set of issues, but that's typically the way this is handled. And so these protective orders are quite important, and the best tool that we have in our civil procedure rules to protect trade secrets. There is no limitation on the types of trade secrets that can be protected. They apply to all trade secrets that meet the definitions under applicable law. With respect to arbitrations, I'll say that protective orders are also quite common in US-based arbitration proceedings, although the primary difference with respect to an arbitration is that there is no public right of access. And so the default or the starting point in most US arbitrations is that the proceeding will be largely private. And with that, I'll go back to you, Philip. Thank you.
Excellent. Thank you, Ryan. So we stay in the common law area, but we move overseas to Jonathan in England.
Thank you very much, and hello everyone. Well, I'll be brief because much of what I'm going to say is going to sound very similar to what Ryan has said, but obviously without reference to a written constitution. In common with everyone else, trade secrets are not automatically protected. One has to apply to court, and the court process does acknowledge the nature of the litigation before it, so it will take steps on application of the parties to protect the information by excluding the public from hearings or parts of hearings, or redacting certain materials, developing protocols for use in the courtroom so that particular information is not identified, for example, and ordering, if the parties cannot agree, inspection protocols for the information so that only certain individuals, sometimes even only certain attorneys, see the information or certain officials within the parties themselves. However, none of that deals with what is often a fundamental issue in considering whether to bring proceedings to enforce trade secrets, which is that in order to litigate about a trade secret, one has to disclose to the other side, the party against whose activities one is seeking protection, the information that one is seeking to protect. And that's why it is more common to see trade secret litigation between a company, a business, and its former employee than it is between two trade competitors. Because obviously the former employee will know the information, they know it by virtue of their employment. That will be the whole basis of the litigation. And it will not be necessary then to disclose to perhaps their new employer, unless one is seeking a remedy directly against that new employer, the very information that one is trying to protect, because it is inevitable in these cases that no matter what protocols or protections one has, that once the information is out there, it is out there. Back to you, Philip.
Well, that's an important point which you mentioned. Now we move to Jane. Good evening to Taiwan. And we have heard now all the countries you have to apply for protection of trade secrets. Is it the same in Taiwan, or do you have a different setup?
Yeah, it's similar here, but the proceedings are a little bit different because in Taiwan, the court proceedings are not like in the US. The proceedings here are open to the public, but the court files, the materials submitted to the court, are only accessible to the parties. So it's automatic, just a little bit like the under seal situation. And if you want to disclose something, and you believe that that is your trade secret, the parties who would like to disclose that can apply for protective order. And the court will determine whether the information should be put under the protective order and who would be included in the protective order. Only the named people in the protective order can access the information, and they have the obligation to keep the information confidential. And if you violate a protective order here in Taiwan, there is criminal sanction waiting for you. So that's a basic situation here in Taiwan.
Thank you much. So then we move to question number 2, and I try to share my screen. So the question number 2 is, what can a company do as a third party involved in the proceedings? And I would like to make an example. Let us assume that the sole distributor is of the view that its contractual partner, the producer of machines, is violating the exclusivity by allowing other distributors to market the machines in the territory too. The sole distributor initiates proceedings against its contractual partner and seeks the production of documents such as list of customers from the third-party companies which the distributor believes are competing in the territory. It also calls officers and employees of such third-party companies as witnesses. Now, those third-party companies, they are afraid that they would have to reveal trade secrets. Let's say, for example, customer lists, which could then be misused by the claimant to actually poach customers. Can the third parties refuse to testify, or refuse to produce documents, or can they obtain protection? I would like to first now ask Ryan about the situation in the US.
Thank you, Philip. So in the US, the third parties essentially have the same rights as the parties do under our applicable rules. And so a third party that would receive a subpoena in a case like this would effectively have 2 options. One would be to object to the subpoena and ask the court to quash it and relieve it of any obligation to present the requested information or testimony, or the third party could respond and seek the entry of a protective order to say, I'll provide the information, but it needs to be adequately protected from public disclosure and perhaps from disclosure to certain parties or officers that are participating in the litigation. So those are the options, and those options are not mutually exclusive. In other words, there's often an objection with a plea that if the information is required to be produced or provided, that it be adequately protected. The courts, obviously have an important balancing role to play, because you have the sole distributor is going to be making arguments to the court as to why it needs the information to prove its case against the defendant. The third party is going to be resisting that and presenting arguments as to the secrecy of its information and the importance that information has, and how important it is to maintain the secrecy of that information. And so essentially the courts engage in a balancing act, and they have to balance those competing interests in ruling on the issue. The result oftentimes is going to be the entry of a protective order where the courts says, well, I need to allow the distributor to prove its case, but I feel like I, as the judge, can provide adequate protections for the trade secret And so oftentimes the result is that the information will be required to be produced or provided subject to the protections that are allowed through the protective order process. And with that, I'll return to you. Thank you, Philip.
Thank you. And I hand over to Jane. What's about Taiwan?
Here, as a third party, you need strategic thinking about whether or not you would like to disclose such information. Because for your own trade secret, sometimes you do not want to disclose it to anyone. So the best solution is not to disclose it, because as a third party, you probably is a witness, or the court may issue a letter to your company asking you questions. And there are all kinds of different ways to answer that kind of letter. But if you, as a third party, are willing to disclose your own trade secret, for example, for purpose of helping one party in the litigation, but you don't want to disclose it to the public, or you would like to protect it, then as a third party, you are able to apply for a protective order also. So just as I mentioned, the court will determine what to put in the protective order, who can access those information provided by you. So that's how, as a third party, you can protect your own information in the proceeding. That's it. And I'll pause here.
Thank you, Jane. But as a third party, if you want to refuse to provide your information, you're entitled to refuse, or can you be required by the court to present it?
Depends on if it is a civil litigation or a criminal proceeding, because trade secret related disputes can be a civil one. And as a third party, your obligation are lighter. So you can, there are always grounds for you to refuse or decline, inactively cooperate to the production, to produce of the documents. But if in a criminal proceeding, if you are summoned as a witness, then usually you have to disclose what you know. But of course, you can carefully think about how you present those information so that you don't disclose too much.
Thank you. Now, Indran, can you tell us about Malaysia, so that we have a kind of a second picture in Asia?
I think as a common law jurisdiction, it's very much similar to the US. But generally, there are two ways in which you secure evidence from a non-party. One, of course, is to voluntarily seek their assistance. That means you approach the third party and ask whether they can produce documents or one of the employees to appear as a witness in the case. Now, in those kind of circumstances, obviously, when it's done voluntarily, there can be some sort of an agreement between the third party and the party to the proceedings, in that they would agree that the party to the proceedings applies for the necessary protection order or sealing order before the documents are produced, or a person from the third party appears as witness. Now, assuming that agreement cannot be reached, then a party to the proceedings can subpoena a witness or documents, very much like as what Ryan has mentioned. And when a subpoena is produced, the witnesses are compelled to give evidence, or the company is compelled to produce the documents. Now, how do you then prevent the documents or the witness from testifying? You challenge the subpoena very much in the way that Ryan has mentioned. You go and challenge the subpoena, and usually subpoenas are challenged on the basis of relevance, whether it's relevant for the witness to appear or whether the documents are relevant to the subject matter of the dispute. So it's very rarely challenged on the basis of it being confidential. So you generally challenge it on relevance. And at that stage, what you could do is that you would say that it's not relevant as a strategic point, and as a compromise, then say that you would produce the documents or the witness would testify subject to the necessary protection order. And now the difficulty with something like that is, unlike parties to the proceedings, and as mentioned by Jonathan earlier, who in most circumstances would already have access to the confidential information, and all you want to do is to prevent access to the general public. Here, a third party would probably be providing that confidential information to parties to the proceedings who may not have had access before the proceedings. So in those kind of circumstances, I think the protection order or the sealing order would have to be carefully crafted to ensure that perhaps the documents or the information be, the exposure to those documents be limited to the counsel, to the action, with a strict undertaking that they may not even want to produce those documents or to provide those documents to their clients. And just maybe the judge and the counsels or such other parties that would be necessary to proceedings with very, very strict undertaking. So from a practical point of view, the protection order in those kind of circumstances need to be very, very carefully crafted and drafted, simply because the information may now potentially go to somebody who would not have had access before the proceedings. Thank you. That would be all. Yeah, thanks.
Thank you, Indran. So we move to sunny Germany. Julia, you're still on mute.
Sorry. Yeah, I am. My answer is not only valid for Germany, but also for most European countries. Unfortunately, there is not much to do for a company which is not itself involved as a party in the proceedings. So the situation is difficult for such a company, and the company really needs to remind, for example, an employer to don't tell too much to the parties and to the court, should remind him on the non-disclosure agreements signed by him. This might have a good effect, as in Germany and in the other European countries, the witness has the right to refuse testifying in front of a court on questions that the witness would not be able to answer without indemnifying himself. That would be the case when he is bound to a non-disclosure agreement or clause, for example, in his employment agreement. So the only thing a company can do, remember his employee of his confidentiality obligations, if such exist, and point out the right to refuse to testify in front of the court. But you always have to have in your memory that this applies only if the owner of the trade secret is not party of the proceedings.
Thank you. And last but not least, England. Jonathan, I have seen that you have been already nodding when our common law panelists shared their view, but still we would like to hear from you.
Oh, thank you. And that's absolutely right. And I'm not going to take long with this question because I don't really have much to add to what Ryan and Indran have already said. The protective orders are available. The key question in whether a court would compel a third party to give evidence or to produce material is going to be one of relevance. And in the example, building on what Indran has already said, that we're working with here, one of the things that occurred to me about relevance is whether actually the third party would have any relevant evidence to give at the question of liability, because they've been asked a customer list, or they're concerned about customer lists. And certainly the way the proceedings would work in England, who had supplied what to which particular customer is likely to become an issue only at the remedy stage, when an order is being sought or damages are are being calculated. So it might well be in the scenario that you set out that the third party could say, well, we will produce this information when we have to, but we don't have to yet. And that is the basis on which they might resist an order being made against them.
Thank you. Then we move to the next question. I try to share again my screen. My next question is, what can a party do if it realizes that its trade secrets are at risk in a third-party procedure? So, for example, it realizes that the distributor is involved in proceedings and that the distributor could reveal some trade secrets. And so now we start with Taiwan, Jane.
Okay. So if you have some information and you believe that that is your trade secret, then the first step you have to do is that making sure that you have a non-disclosure agreement, the NDA, with your business partner, so that if your business partner is involved in the litigation and you feel that your own trade secret is in danger, so that you can remind your business partner of his confidentiality obligation, because usually it includes that you should keep it confidential, and if you are forced to disclose it to the court, you need to inform the company in advance so that you can limit it, the scope of disclosure to the extent possible. And for example, if you are able to file for a protective order, and you should do so. So so that's it. Having a non-disclosure agreement and remind the third party of its rights or its grounds to, if you don't want the third party, your distributor, to disclose such information, that distributor may consider, like, if there is legal ground for the distributor to refuse to be the witness, or as I mentioned earlier, try every possible method to limit the disclosure. That's what you can do to protect your own own trade secret.
Thank you, Jane. And now the common law view, I would like to ask Jonathan. Jonathan, you're still on mute.
Jonathan, we have you on mute.
There, sorry, technological fail. And I was just saying it was going to be rather difficult for me to comment on behalf of all common law countries, and was going to confine myself to England and see if my colleagues agree. But this is one of the interesting things about trade secrets. In your first question, Philip, you asked us whether there's automatic protection, and we all said, no, you have to apply to the courts, and that the situation would be the same here. But it's the basis of the application that we would need to concentrate on. You can't just assert, that's my trade secret, you must not disclose it. What duty do you owe me that means I have a right to stop you from disclosing my trade secret? And as Jane said, the most obvious one to look for is a contractual duty. What is your contract with your distributor? Is there a non-disclosure provision in there? It's possible that the duty could arise in other circumstances. There could be a duty of confidence between you and a former employee. There could be an implied duty of confidence because of the way that the information had been given to the third party. That can arise in all sorts of situations. But without an express non-disclosure agreement there, then it's fair to say that you're going to find it very difficult. That the nature of a trade secret is it's not a form of intellectual property. You can't patent it, you can't copyright it. You have to find some other right, usually a duty of confidentiality, that you can attach to it in order to be able to protect it. So what I would say, and it'll be interesting to see what my colleagues in Malaysia and the US say, is check the contractual arrangements. That's the first place to look, that you have with the third party, to see what duties in respect of trade secrets are in that. And it's on those that you would bring proceedings before the court.
Yeah, and we have pre-discussed that, and in order to keep our time, which we have available, I was told by my colleagues in the US and in the other participating countries that the situation is basically the same as mentioned by Jonathan and Jane. You have to focus on agreements which you have with this other party, and base your request on confidentiality obligations which are based on those agreements. We got the question which I would like to pose already at this stage, because I think it's a very important and good question, and that's the question that we are talking about trade secrets all the time, but what is exactly a trade secret, whether it's defined by law, and what does the definition say? Can anybody of you give an answer to that question?
Could I try, Philip?
Yes.
Generally, it's the definition of trade secret is actually defined not by its rights, but rather by its breach. Generally, it's defined by its breach. So if you are bringing in an action, it's actually to protect a trade secret, you first have to, it's actually a three-pronged test. Number one, the information concern must have the necessary element of confidentiality or trade secrets, in the sense that it's not in the public domain, and it's something that companies would want to protect. And it is not just limited to formulas, secret formulas, or patented documents, or an industrial design which has not been disclosed, but it can also be extended to, say, customer list, price list, a whole host of things that are not in the public domain and which have some value to a company. So that's the first element. The second element is the information concerned is imparted in an occasion of confidence. So just say someone has access to that information, it was imparted in an occasion of confidence, and usually it will arise from business partners when you have an NDA, an employer-employee relationship. And the third element is, if the information is disclosed, would there be damage caused to the person who's claiming confidentiality over it? So it's a three-pronged test, in the sense it must have an element of confidence and secrecy. It's imparted in an occasion of confidence, and thirdly, if it's disclosed, there's going to be damage caused to the person who maintains a trade secret. So generally, it's defined more by its breach rather than by its by the fact of whether it's trade secret or not.
So perhaps I may add something from the European point of view. Only recently we got a definition by law. It is based on a directive of the European Council, and it says it has the two elements Imran mentioned, but it has a third element, and which is now new in the most of the European countries. And it says, I will read it from the directive: it has been subject to reasonable steps under the circumstances by the person lawfully in control of the information is to keep it secret. So by definition, you have to take measures to make sure that the secret is protected. And in case of a lawsuit, you have to demonstrate that you took all these measures. So, but that's new under the European laws.
I can add something here. As the statutory law system here, we do have definition of trade secret, which are very similar to what Julia has mentioned. The trade secret is defined under the Trade Secret Act here in Taiwan. And there are three major elements. First, it has to be not in the public domain. And the second one is that it should have some value. And the third one, which is also the most important one, is that you have to take proper measure to keep it in confidential. So just as what Julia has mentioned, this is the most arguable issue in defining whether an information is trade secret or not. You have to prove that what measures you have taken to protect the secrecy.
Thank you very much. Then I would like to move to question 4. The question is whether there is any difference in the protection of trade secrets if a claim is brought by a whistleblower. And I would like to start with Jonathan and the situation in England.
Well, the short answer is in principle, no. There won't be any difference. If it's a trade secret and it should attract protection, then it will attract protection. However, the court, in considering the remedies available to it, will take into account the nature of the disclosure, the purpose of the disclosure, the person making the disclosure. It is inconceivable that a court would prevent a trade secret from being disclosed to a regulator in circumstances where it was proper to disclose that information to a regulator. And it's quite hard to see how relevant information shouldn't be disclosed to a regulator. Similarly, if you have someone who is whistleblowing and bringing a matter to public attention, which should be brought to public attention, that the trade secret is that something is going to cause the public harm, for example, then again, I think it very, very unlikely that a court in practice would grant any remedy restraining the dissemination of that information or requiring damages from the person who disclosed it. So although in theory there is no difference, in practice the nature of the information disclosed, to whom it was disclosed, why it was disclosed, can be very material.
Thank you. And I would also ask Julia to share the situation in Europe, in the European Union.
That was nicely spoken. Sorry for that, Jonathan. You are still part of the European Union. So I really have only a very few sentences to add. Jonathan's answer was based, or is based, on the European directive. And in fact, there is no difference, or by law, there is no difference whether it is whistleblower or not. But in reality, it does make a big difference. And this is because the European directive and the German Trade Secret Act as well, and almost all European trade secrets laws also deal with whistleblowers disclosing hidden facts in a way that the legal prerequisites for classification these facts as a trade secret are not fulfilled. The disclosure by a whistleblower is not a mere ground for justification or an excuse, but it omits the characteristic valid interest of non-disclosure of the trade secret.
Thank you. So again, for the sake of time, we have discussed this earlier with all the panelists, and I was told that basically in the other jurisdiction, there is not really a material difference whether it's trade secret is brought up by a whistleblower or by any other party. That's why I would like to move to our last question, question number 5. And I do again share my screen so that you can read it. We have now been discussing the protection for trade secrets when the proceedings are about to start or already pending. Our audience is certainly interested in knowing what steps can be taken before the proceedings start in order to improve protection for trade secrets. And it will be Julia again who will share now her suggestions.
Thank you, Philip, again. I have very few, very strict recommendations to companies. First of all, make an inventory of all trade secrets of the company. Categorize them according to their importance and value for the company. Implement appropriate protection measures as marking confidential documents, limit the access to the trade secrets, implement the respective IT protection measures, instruct the respective employees on a regular basis of the importance of the trade secrets. Almost include non-disclosure clauses in agreements with business partners as well as with employees, and in case it's possible, bake them up with contractual penalty clauses. Conclude non-disclosure agreements with parties who get access to trade secrets even before you start to negotiate a contract with them. And finally, develop procedures to act rapidly if you get notice of disclosure of one of the trade secrets. I think in case you think in advance of taking these measures, there shouldn't be too much harm to your company in case of proceedings in which trade secrets can be the subject matter.
Thank you very much, Julia, for these important proposals. Now I would like to ask Jane whether there is anything to add from her perspective.
I agree with everything Julia has said, and I would like to add something as a litigator. The first one is that jurisdiction, because multi-jurisdictional disputes are very common nowadays. It is very common that, for example, a Taiwanese company, ex-employee brings the trade secret and to company B to country B and for bidding a country C customer's purchase order. So that's very common. And if you are the owner of the trade secret, you would like to sue that your ex-employee or sue your competitor, you may consider in which jurisdiction would you want to initiate the litigation. So which means that you need to know the practice of each jurisdiction involved. For example, here in Taiwan, we often encounter issues that involves Taiwan, China, Japan, Korea. It's very common, and US, of course. So you need to know the practice of each jurisdiction, including is your trade secret protectable, or if yes, or if not, how the procedure would like. And of course, you need to care about the cause of action, because sometimes going for a trade secret claim is not the most effective one. For example, you may add some clause as a covenant not to compete after the termination of the employment. So you may have a claim of breach of contract and something like this. So what I would like to say is that very often that a trade secret case involves different countries, and you need to know the practice, your business goal, including the time frame and the cost, of course. And those are the factors that should be taken into consideration before the proceeding starts, no matter you are a potential plaintiff or defendant. That's very important. That's my comment.
Thank you, Jane. And to conclude, I would like to ask Ryan about the US.
Yeah, so as in, I think the other jurisdictions in the US, in order to qualify for trade secret protection, a business has to take reasonable measures to protect the secrecy of the information. And, you know, for many businesses, that's far easier said than done. I mean, if you think about running a business with multiple employees, with, you know, IT systems, you really have to think hard about how to protect that information, how to restrict access to it. That's typically done in a few different ways. I would say principally through contractual NDAs, both with your employees as well as with any external third parties who may be privy to the information. And also, I think one of the things I've seen in recent years is the IT side of things. Is if the information, as most trade secret information is, resides on your computer system or a company's computer system, you really have to be thoughtful about how you're going to protect that information, who's going to have access to it, making sure it has password protections and things of that nature. I often find, you know, many of my clients, they call me and they say, hey, so-and-so is one of my competitors has my price list. And oftentimes, you know, they're upset about it. And they think their price list is a trade secret or somehow protected, and there's been some wrongdoing. And a lot of times with a couple of questions, you can determine that, in fact, the information's not a trade secret. I mean, if you can call up a business and say, how much would it cost me to buy X piece of equipment from you, and the business is willing to provide that information, then obviously they're not taking reasonable measures to protect the secrecy of that information. On the other hand, if you're requiring all potential customers to enter into some form of a confidentiality agreement before you provide them information regarding your pricing and the details of your equipment, then that's a different story. But again, the touchstone in the US really is, are you taking reasonable measures to protect the secrecy of the information that you're claiming as a trade secret?
Thank you very much, Ryan. That concludes my questions. I see that we are already a little bit over the time, but still I hope we have time to answer one more question. And that question is, well, if there is confidential information which does not amount to a trade secret, whether there is similar protection or what would be the situation with this kind of confidential information which you would not qualify as a trade secret?
Philip, this is Ryan. I'll briefly respond to that. From a U.S. perspective, if we're talking about the interim protection of information during the course of litigation and its relationship to protective orders, the answer is there really is very little difference. And the courts are typically willing to protect, through the protective order process, confidential information, proprietary information, commercially sensitive information, in the same way that they are trade secrets. If you, on the other hand, We do have specific trade secret statutes in the United States which provide for a cause of action if you can show a misappropriation of a trade secret, which you know, those are trade secret specific statutes and wouldn't apply to information that does not qualify as a trade secret but might otherwise fall into one of these other categories of information that I've mentioned.
Perhaps I may add for Germany, all what we have said about the usual proceedings is valid for preliminary injunctions as well. In preliminary injunction proceedings, the court only has to look at the case overview-wise and check preliminary whether a trade secret could be effected or not. He does not need to make a final decision, but only overview-wise, knowing that it's only the first step in perhaps longer proceedings, and he will be carefully to not protect trade secrets in preliminary injunctions proceedings.
Philip, can I just add to what Ryan has said? In Malaysia, the courts don't generally make a distinction between a trade secret or confidential information. And I think, as I mentioned in answer to the first question, there's always a balancing exercise done between getting the dispute resolved and to what extent the trade secret is relevant or the confidential information is relevant to the determination of the dispute against the need to protect the trade secret or confidential information, and the measures that could be taken to ensure that both interests are taken care of, that resolving the dispute in the best possible manner, and at the same time protecting the confidential information and trade secret. And I think it's not a given that just because a party asserts that information is confidential or it's a trade secret that the court is going to grant the protective order, because in line with what Ryan also mentioned earlier on court proceedings being public and the fact that the public should actually have access to see how court proceedings and justice is being delivered. So balancing all these interests, the court will then have to decide between resolving the dispute, having the public have access to justice and having access to how justice is being administered, as well as protect the trade secret. So all three are taken into consideration, and then the right balance is determined by the judge.
Excellent, thank you very much. And now, in view of the time, which is already nearly 10 minutes above the hour, I would like to conclude at this point and thank you very much all my panelists, to Julia in Germany, to Jane in Taiwan, to Indran in Malaysia, to Ryan in Atlanta, Georgia, and to Jonathan in London. Thank you much. It was very interesting.
Thank you, Philip.
Moderator.
Thank you very much.
Thanks, thank you, everyone.
Thank you, Philip. And on behalf of World Law Group, thank you all for joining today. And I echo Philip's thank you to our panelists. We have recorded this webinar and it will be posted on our website along with email details for the panelists. This webinar is part of a 3-week fall e-conference, so I encourage you to visit our website and check out other sessions taking place that may be of interest to you or your colleagues. With that, have a pleasant day or evening, and stay healthy and well wherever you are.
Thank you all. Bye.
Thank you. Bye-bye.